Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. Let's get started with question number 1. Desmond fell while attempting to climb a mountain and lay unconscious and critically injured on a ledge that was difficult to reach. Pearson, an experienced mountain climber, was himself seriously injured while trying to rescue Desmond. Pearson's rescue attempt failed and Desmond died of his injuries before he could be reached. Pearson brought an action against Desmond's estate for compensation for his injuries. In this jurisdiction, the traditional common law rules relating to contributory negligence and assumption of risk remain in effect. Will Pearson prevail in this action against Desmond's estate? A. Yes, if this rescue attempt was reasonable. B. Yes, if the law should not discourage attempts to assist persons in helpless peril. C. No, unless Desmond's peril arose from his own failure to exercise reasonable care. Or D. No, because Pearson's rescue attempt failed and therefore did not benefit Desmond. Take 10 seconds, choose the best answer now. If you chose option C, you'd be correct. No, unless Desmond's peril arose from his own failure to exercise reasonable care. Remember that to establish a prima facie case of negligence, you must show duty, a breach of that duty, causation, and damages. The basic standard of care is that of the reasonable person acting under like circumstances. There's no duty owed to unforeseeable victims, but injuries to rescuers are not considered unforeseeable. In this case, Pearson was seriously injured while trying to rescue Desmond, who fell and lay unconscious and critically injured on a ledge that was difficult to reach. Pearson's action against Desmond's estate would be based on a theory of negligence, so Pearson would only prevail if Desmond breached some duty by placing himself in danger, i.e., Desmond's peril arose from his own failure to exercise reasonable care. Question number 2. In which of the following cases is a conviction of the named defendant for robbery least likely to be upheld? A. Johnson forced his way into a woman's home, bound her, and compelled her to tell him that her jewelry was in the adjoining room. Johnson went to the room, took the jewelry, and fled. B. A confederate of Brown pushed a man in order to cause him to lose his balance and drop his briefcase. Brown picked up the briefcase and ran off with it. C. Having induced a woman to enter his hotel room, Ritter forced her to phone her maid to tell the maid to bring certain jewelry to the hotel. Ritter locked the woman in the bathroom while he accepted the jewelry from the maid. Or D. Hayes unbuttoned the vest of a man too drunk to notice and removed his wallet. A minute later, the victim missed his wallet and accused Hayes of taking it. Hayes pretended to be insulted, slapped the victim, and went off with the wallet. Take 10 seconds to choose your best option now. If you chose option D, you'd be correct. Hayes unbuttoned the vest of a man too drunk to notice and removed his wallet. A minute later, the victim missed his wallet and accused Hayes of taking it. Hayes pretended to be insulted, slapped the victim, and went off with his wallet. Larceny is the wrongful taking and carrying away of another's tangible property without consent and with the intent to permanently deprive. Robbery is larceny plus force or threat of imminent or immediate harm. Since larceny is a part of robbery, a defendant cannot be found guilty of both robbery and larceny. Here, the named defendant Hayes is the only defendant who does not use force when taking another's personal property. Hayes unbuttoned his victim's vest without the need for force because his victim was too drunk to notice, and then Hayes removed the victim's wallet. At this point, Hayes may be guilty of larceny, but not robbery. This is in stark contrast to the other scenarios where defendants either bound, pushed, or otherwise used force to take another's personal property. While Hayes later slapped the victim, this use of force was after Hayes had taken the victim's wallet. Thus, a conviction of Hayes for robbery is the least likely to be upheld. Question number 3. The state of Aurora requires licenses of persons who are engaged in the trade of barbering. It will grant such licenses only to those who are graduates of barber schools located in Aurora itself. who have resided in the state for 2 years and who are citizens of the United States. The requirement that the candidate for license be a citizen is A, constitutional, as an effort to ensure that barbers speak English adequately, B, constitutional as an exercise of the state police power, C, unconstitutional as a bill of attainder, or D, unconstitutional as a denial of equal protection. Take 10 seconds, choose the best answer now. If you chose option D, unconstitutional as a denial of equal process or protection, you'd be correct. Equal protection is invoked when a law treats one person or class of persons differently from others. The Equal Protection Clause of the 14th Amendment applies equal protection to the states. Alienage classifications are generally subject to strict scrutiny, meaning that the law is unconstitutional unless it is necessary to achieve a compelling governmental purpose. Here, Aurora's license restriction discriminates in part against those who are not citizens of the United States by preventing non-citizens from obtaining an Aurora barbering license. This alienage classification is subject to strict scrutiny. There is no evidence of this restriction being necessary to achieve any compelling governmental purpose, so the classification does not in fact pass strict scrutiny. Thus, the requirement that candidates must be citizens is unconstitutional on its face as a denial of equal protection. Question number 4. Mary Webb, a physician, called as a witness by the defendant in the case of Parr v. Doan, was asked to testify to statements made by Michael Zadok, her patient, for the purpose of obtaining treatment from Dr. Webb. Which of the following is the best basis for excluding evidence of Zadok's statements in a jurisdiction with a doctor-patient privilege? A. An objection by Dr. Webb asserting her privilege against disclosure of confidential communications made by a patient. B. An objection by Parr's attorney on the grounds of the doctor-patient privilege. C. A finding by the trial judge that Zadok had left the office without actually receiving treatment. Or D. The assertion of a privilege by Zadok's attorney present at the trial as a spectator at Zadok's request and allowed by the trial judge to speak. Take 10 seconds. Choose what you think is the best answer now. If you chose option D, the assertion of a privilege by Zadok's attorney, present at the trial as a spectator at Zadok's request, and allowed by the trial judge to speak, you'd be correct. The doctor-patient privilege, where recognized, states that a patient has the privilege to prevent disclosure of any communication by a physician intended by that patient to be confidential and conveyed for the purpose of receiving medical diagnosis or treatment if the information conveyed was in fact pertinent to medical diagnosis or treatment. In this case, Mary Webb, a physician, has been called to testify to statements made by Michael Zadok, her patient, for the purpose of obtaining medical treatment from Dr. Webb. Zadok, however, is not a party to the case of Parr v. Doan. As such, the assertion of a privilege by Zadok's attorney present at the trial as a spectator at Zadok's request and allowed by the trial judge to speak would be the best basis for excluding these statements. Question number 5. As a result of an accident at the NPP nuclear power plant, a quantity of radioactive vapor escaped from the facility and 2 members of the public were exposed to excessive doses of radiation. According to qualified medical opinion, that exposure will double the chance that these persons will ultimately develop cancer. However, any cancer that might be caused by this exposure will not be detectable for at least 10 years. If the 2 exposed persons do develop cancer, it will not be possible to determine whether it was caused by this exposure or would have developed in any event. If the exposed persons assert a claim for damages against NPP shortly after the escape of the radiation, which of the following questions will not present a substantial issue? A. Will the court recognize that the plaintiffs have suffered a present legal injury? B. Can the plaintiffs prove the amount of their damages? C. Can the plaintiffs prove any harm they may suffer was caused by this exposure? Or D. Can the plaintiffs prevail without presenting evidence of specific negligence on the part of NPP? Take 10 seconds. Choose the best answer now. If you chose option D, you'd be correct. Can the plaintiffs prevail without presenting evidence of specific negligence on the part of NPP? The rule is that a person is strictly liable for any harm that occurs while engaging in an abnormally dangerous activity, so long as the harm results from the kind of risk that made the activity abnormally dangerous in the first place. Safety precautions taken by the defendant are completely irrelevant. In this case, plaintiffs were allegedly exposed to excessive doses of radiation as a result of an accident at the NPP nuclear power plant. A nuclear power plant is an abnormally dangerous activity, and since this would be the type of harm that makes a nuclear power plant abnormally dangerous in the first place, the plaintiffs would not need to prove any negligence on the part of NPP. NPP would be strictly liable for any harm caused by this exposure. As such, whether or not the plaintiffs can prevail without presenting evidence of specific negligence on the part of NPP would not present a substantial issue if the exposed persons asserted a claim for damages against NPP. Question number 6. The state of Aurora requires licenses of persons who are engaged in the trade of barbering. It will grant such licenses only to those who are graduates of barber schools located in Aurora, who have resided in the state for 2 years, and who are citizens of the United States. Assume that a resident of the state of Aurora was denied a license because she had been graduated from an out-of-state barber school. Her suit in federal court to enjoin denial of the license on this ground would be A. Dismissed because there's no diversity jurisdiction, B. Dismissed because of the abstention doctrine, C. Decided on the merits because federal jurisdiction extends to controversies between two states, or D. Decided on the merits because a federal question is involved. Take 10 seconds. If you chose option D, decided on the merits because a federal question is involved, you'd be correct. Federal courts can hear all cases in law and equity arising under the Constitution. The Dormant Commerce Clause is inferred from the constitutional granting of power to Congress in the Commerce Clause to regulate interstate commerce. If Congress has not acted, a state or local government may regulate local aspects of interstate commerce, unless the state or local laws discriminate against out-of-staters or place an undue burden on interstate commerce. The Privileges and Immunities Clause of Article 4 states that no state may discriminate against non-residents with respect to privileges and immunities. A state or local law that discriminates against out-of-staters with respect to civil liberties or commercial activities violates the Privileges and Immunities Clause of Article 4, unless that state or local law is necessary to achieve an important governmental purpose. In this case, a resident of Aurora was denied a barber license because she graduated from an out-of-state barbering school. Aurora will only grant licenses to those who are graduates of barber schools located in Aurora itself, who have resided in the state for 2 years, and who are citizens of the United States. The policy of only granting licenses to those who have graduated from barber schools in Aurora is an undue burden on interstate commerce, i.e., no graduate from an out-of-state barber school can practice in Aurora. Further, this policy discriminates against out-of-staters with respect to fundamental economic activities that affects this resident's ability to earn a livelihood. As such, this case would be decided on the merits because a federal question is in fact involved. Question number 7. A leading question is least likely to be permitted over objection when A. Asked on cross-examination of an expert witness, B. Asked on direct examination of a young child, C. Asked on direct examination of a disinterested eyewitness, or D. Related to preliminary matters such as the name or occupation of the witness. Take 10 seconds. Choose the best answer. If you chose option C, asked on direct examination of a disinterested witnesses, you'd be correct. A leading question is a question that suggests the answer to the witness. Generally, no leading questions are allowed on direct examination. Exceptions include questioning an adverse witness, hostile witnesses, or a witness that needs help. Leading questions for preliminary matters not in dispute are also permitted. A disinterested witness is neither hostile nor adverse. Therefore, no exception to the general rule excluding leading questions applies here. Therefore, the question is unlikely to be permitted over objection under that scenario. Question number 8. In preparation for a mountain climbing expedition, Alper purchased the necessary climbing equipment from Outfitters, Inc., a retail dealer in sporting goods. A week later, Alper fell from a rock face when a safety device he had purchased from Outfitters malfunctioned because of a defect in its manufacture. Thereafter, Rollins was severely injured when he tried to reach and give assistance to Alper on the ledge to which Alper had fallen. Rollins' injury was not caused by any fault of his own part. If Rollins brings an action against Outfitters, Inc. to recover damages for his injuries, will Rollins, in fact, prevail? A. No, unless Outfitters could have discovered the defect by a reasonable inspection of the safety device. B. No, because Rollins did not rely on the representation of safety implied from the sale of the safety device by Outfitters. C. Yes, unless Alper was negligent in failing to test the safety device. Or D. Yes, because injury to a person in Rollins' position was foreseeable if the safety device failed. Take 10 seconds. Choose what you think is the best answer now. If you chose option D, yes, because the injury to a person in Rollins' position was foreseeable if the safety device failed, you'd be correct. The general rule is that a seller of a product is strictly liable for injuries caused by defective products. Privity is not required for products liability actions based on strict liability theories. Any foreseeable plaintiff, including a bystander, can sue for products liability even if there's no contractual relationship between the plaintiff and the commercial supplier. Here, Outfitters is strictly liable to Rollins for his injury caused by assisting Alper after Alper's safety device malfunctioned. Rollins does not have to be in privity with Outfitters to establish Outfitters' liability, since it was foreseeable that a bystander like Rollins would lend help to a climber like Alper whose safety device just failed. Thus, Rollins will prevail in an action against Outfitters because injury to a person in Rollins' position was foreseeable if the safety device failed. Question number 9. The state of Aurora requires license of persons who are engaged in the trade of barbering. It will grant such licenses only to those who are graduates of barber schools located in Aurora, who have resided in the state for 2 years, and who are citizens of the United States. Which of the following is the strongest ground on which to challenge the requirement that candidates for barber licenses must have been residents of the state for at least 2 years? A. The Privileges and Immunities Clause of the 14th Amendment. B. The Due Process Clause of the 14th Amendment. C. The Equal Protection Clause of the 14th Amendment. Or D. The Obligation of Contracts Clause. Take 10 seconds. This was as close to a gimme as you can get. You should have chosen option C, the Equal Protection Clause of the 14th Amendment. Equal protection is invoked when a law treats one person or class of persons differently from others. Equal protection provides that all citizens must be offered the equal protection of the laws. The Due Process Clause of the Fifth Amendment applies equal protection to the federal government, and the Equal Protection Clause of the 14th Amendment applies equal protection to the states. In this case, the state of Aurora is treating people who have been residents of Aurora for 2 years differently than those who have not. Since we're dealing with the state, the strongest ground to challenge this requirement would be the Equal Protection Clause of the 14th Amendment. The standard for review would be rational basis review, since this is an economic regulation. Question number 10, the last question in this grouping. Penn sues Duke's Bar for injuries suffered in an automobile accident caused by Chase, who had been a patron of Duke's Bar. Penn claims that Chase was permitted to drink too much liquor at Duke's Bar before the accident. Wood, a patron of Duke's Bar, testified that on the night of the accident, Chase was drunk. Wood then proposed to testify that he remarked to his companion, "Chase is so drunk he can't even stand up." Wood's remark to his companion is A, admissible as an excited utterance, B, admissible as a prior consistent statement, C, admissible as a statement by Wood regarding a condition he observed, made while he was observing it, or D, inadmissible if there was no evidence that Wood had expertise in determining drunkenness. Take 10 seconds. Choose your best answer now. If you chose option C, you'd be correct. Admissible was a statement by Wood regarding a condition he observed made while he was observing it. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is generally inadmissible. One hearsay exception is the present sense impression exception. A hearsay statement of a present sense impression is admissible if describing or explaining an event or condition made while the declarant is in fact perceiving the event or immediately thereafter. Excitement is not required. Here, Woods' out-of-court statement was a present sense impression of Chase being drunk while Wood observed Chase being drunk. This present sense impression is admissible as a hearsay exception. Therefore, Woods' remark to his companion is admissible as a statement by Wood regarding a condition he observed while he was in fact observing that condition. Thank you for joining us on Bar 10 Test Prep as usual. Don't forget to like, subscribe, and click the notification bell so we can update you every time we upload new content. It's our goal to upload new content at the very least every day at 8 a.m. Eastern Standard Time.